Hi, I'm Kayla Henderson. I'm an attorney and pro bono coordinator at Inland County's Legal Services in Riverside, California. And today we're going to be talking about employment law pitfalls and very real and potentially very expensive consequences for small business owners. Training, we're going to identify high-level critical information about California and federal employment laws, identify common pitfalls and issues among small businesses, and identify potential consequences of violating employment laws. We're going to go over the size of the company, how many employees do they have, exempt versus non-exempt employees, wage and hour compliance, meal periods and rest breaks, overtime requirements, and classifying employees versus independent contractors. Employment law is a very broad and very complex area of law, and obviously we would not be able to cover all of that today. This is a very high level overview of what small businesses may run into when they hire their first few employees and what they should know if they are a small business or even a first-time employer. So the size of the company matters. Under California and federal law, depending upon how many employees the employer has, different laws will apply. So if you have one employee, possible compliance and liability includes wage and hour laws, sexual harassment, paid family leave, paid sick pay, insurances, including state disability, unemployment, and workers' compensation. I want to highlight workers' compensation. Many small business owners are not aware that it is illegal not to have workers' compensation insurance if you have one or more employees. They don't know that it's illegal not to have it. They have heard that it's expensive and they just don't want to get it. It is very important to ask if they have workers' compensation insurance if they already have employees, but it's also important to highlight if they plan on hiring an employee that they have to have that insurance the day the employee starts. It's very important. If they have 5 or more employees, all of the above that we just mentioned are required, plus discrimination, retaliation, and harassment laws come into play. And if they have 15 or more employees, it was all of the ones I mentioned before, plus discrimination, retaliation, harassment, plus some more federal laws. So as the company grows and the size and the number of employees change, the requirements under the law change. Next, it's important for the employer to know how to classify their employees as exempt versus non-exempt. Non-exempt employees exercise discretion and independent judgment while performing their work. Generally, if the employee is engaged in exempt work that meets the requirements for the exemption more than 50% of their work time, then they are exempt. And exempt employees are paid on a salary basis. And we'll talk more about the salary basis on the next slide. Exempt employees must be paid a minimum salary. In California, exempt employees must be paid a salary that equals at least twice the applicable minimum wage for full-time employees. In 2024, that minimum salary is at least $66,560 per year based on the current minimum wage, but it will be going up in 2025 to $16.50 an hour. So the minimum monthly salary for exempt employees will also change because it must equal at least twice the applicable state minimum wage. So that also will be going up in 2025. It's also important to point out that just paying an employee a salary does not automatically make them exempt. As I mentioned in the previous slide, there are certain requirements on how the work is performed for exempt employees. Next, wage and hour compliance. Wage and hour covers federal, California, and sometimes local laws. Sometimes there are local minimum wage, paid sick leave, lactation accommodation breaks, depending upon the city or county. So it's important to know where the employer is located and what possible local rules could also come into play. The employer must comply with the standard that is more protective of the employee. An example would be here in California, we have a higher minimum wage than the federal, so they must be paid the higher minimum wage in California. California will see another increase to its minimum wage on January 1st, 2025. Like I mentioned, when we were talking about exempt employees. On this date, the state minimum wage will increase from $16 to $16.50. The increase applies to all employers regardless of size. The increase will also impact other exemption thresholds, as I mentioned, especially the minimum exempt salary. Again, please note many cities and counties in California have a higher minimum wage, so it's important to know where the employer is located. Meal period and rest breaks. Again, sometimes this is not understood by small business owners or first-time employers. For meal breaks, employers must provide non-exempt employees, so hourly employees, who work 5 hours or more with a meal period of at least 30 minutes and a second meal period of at least 30 minutes for employees who work 10 hours or more. The meal period can be unpaid. An employer must also relieve the employee of all duty for the designated period, meaning that they are not required to work at all during that 30 minutes. Meal period must begin before the end of the 5th hour of work, and a second meal period before the end of the 10th hour of work. Next, rest breaks. Employers must provide non-exempt or hourly employees with a paid 10-minute off-duty rest break for every 4 hours worked or a major fraction thereof, which would be 3.5 hours or more. Employees may take a second paid rest period if they work more than 6 hours in a day, and a third paid rest break if they work more than 10 hours in a day. And rest breaks should fall in the middle of the work periods insofar as practical. Employers who fail to provide an employee with meal or rest breaks are subject to 1 hour of penalty pay at the employee's regular rate of pay per day for missed meal periods and 1 for missed break periods. So this can add up very quickly. If it has been going on for months or even years, this could be in the thousands of dollars in penalty pay if the employer is not providing the meal or rest breaks correctly and an employee files a complaint. Overtime requirements. California overtime laws require that non-exempt employees to earn 1.5 times their regular rate of pay when they work extra hours. In some cases, employees receive double pay for working overtime. Work that triggers overtime pay for non-exempt employees or hourly employees in California, if an employee works more than 8 hours, up to 12 hours in a workday, they are paid time and a half. If they work more than 40 hours a work week, they are paid time and a half. If they work more than 6 consecutive days in a work week and work no more than 8 hours on the 7th consecutive day, they are paid time and a half. Double pay kicks in when they work more than 12 hours in a workday or more than 8 hours on the 7th consecutive day in a work week. Working off the clock is strictly prohibited for non-exempt employees. Non-exempt employees, again, are hourly employees, so it is strictly prohibited for an hourly employee to be working off the clock. An hourly employee or non-exempt employee must be paid for every minute worked. Next, employee versus independent contractor classifications. This is also a very common misunderstood area for small business owners and first-time employers. Many employers operate under the misconception that an individual can be classified as an independent contractor by signing an agreement to be an independent contractor or by working somewhere other than the employer's normal place of business. This is simply not the case. Also, a lot of small business owners or first-time employers also think that just by using a 1099, that the person is automatically an independent contractor, and that is not the case. A common mistake is classifying an individual as an independent contractor when they're really an employee. In California, there is a presumption that all workers are employees. So employees are entitled to benefits such as minimum wage, workers' compensation, unemployment insurance, expense reimbursement, paid sick leave, paid family leave, and employers pay half of the employee's Social Security tax. So individuals who are independent contractors are not considered employee for wage and hour purposes. There is not one single definitive factor in determining whether an individual is an independent contractor or an employee for the purpose of wage and hour laws. Okay, so classifying employees versus independent contractors. In order to determine if someone is an independent contractor or an employee, California uses a strict three-part ABC test. Under this ABC test, an individual is presumed to be an employee unless the hiring company can prove that the worker, number one, is free from control and direction of the hiring entity in connection with the performance of the work, both under the contract for the performance of the work and in actually doing the work. Number two, performs work that is outside the usual course of the hiring entity's business and is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. The individual has to meet all three requirements. This is an and, not an or. So all three parts of the ABC test must be met. Failure to satisfy each of the three elements of the ABC test will result in an individual being classified as an employee. However, California's worker classification law contains dozens, if not more, of complicated exceptions to the ABC test for various industries and professions. So, and if an exemption applies, then the courts and agencies will apply the tests specified in the statutory exception, usually the common law tests. If an exception applies, then courts and agencies will apply the test specified in the statutory exception, usually the common law control test, sometimes called the Borello test. The Borello test is more flexible, and it focuses primarily on the hiring entity's right to control the manner and means of performing the work, but it also takes into account several other factors. I think it's close to 12. So because different tests are applied depending upon the legal issue and the specific circumstances of the business, employers should always consult with legal counsel to make sure workers are classified. If they have already classified independent contractors, that classification should be reviewed because they may have not done it correctly. So as I mentioned, an employer should evaluate the status of their current contractor relationships to make sure that those contractors are properly classified. They should avoid engaging contractors to perform functions integral to their business. They should avoid exercise of control and ensure that contracts indicate no control. They should avoid engaging individuals who do not have an established independent business as independent contractors. They should also establish a written policy on the engagement of independent contractors and how those relationships will be managed. They need to centralize decision-making regarding engagement of independent contractors within their own business. And of course, review contractor agreements for consistency with the ABC test and the three elements of the ABC test. Thank you for joining us and have a great day.